see get the same thing which they stopped going on as it started. That is what I wanted to ask.
Wiki, you've made a wonderful question. The High Court has stopped the process. That is very true. We expect government to go to Supreme Court. But looking at that, we have a government that is not known for obeying court orders or following the law for that matter. These will be interesting times to look at how government chooses to handle this ADANI deal, being that it has evoked quite the emotions in this country. We have people who say JKIA is part of our heritage. It should be kept for our children as a mark of what we were able to do once we attained independence. Those are some of the things we should be looking at and talking about today. Why the rush and who else was bidding for this thing? How did we end up saying that ADANI was the best deal for Kenya? Those are some of the questions I hope after KA have gone through this document. I think anytime Wakil will be joining us, he will also be able to shed light on the questions you asked. Because if KA staff have the document, I believe now the document will be made public. One of the things most Kenyans don't know that if this was a government negotiated deal, then the Attorney General sat on that panel. And if this deal was for the public interest, as they say, because JKIA is a public asset, then those documents should be made available to all Kenyans on request. So those are some of the things we want to delve deep into and look at and ask ourselves, is this the best deal? But we shall get to know that soon, because the documents have been made available. I see Wakili Ndegwa has joined us. And any questions you have for Wakili, this is the best time to ask for them, to ask those questions so that he has the time to write them and reply to all of you once. Now, Wakili has made today, Ruto and Ashoka, they filed a petition in court, which is very different from what KA, LSK, and the human rights did. So we shall also be knowing what's the difference between the two cases. Thank you, Wakili. Now, Wiki, you asked a question, and I see, if you could repeat the question for Wakili to hear, because I'm not a lawyer, I might not have the language for that.
Thank you very much. Wakili Ndegwa, my question is, I saw a notice from High Court stopping anything to do with ADANI and JKIA. Now, in the recent court, we have seen High Court being used to cool the temper of people. In other words, whatever they stop, at long last, it ends up the way it started. We have seen very many cases being stopped. We saw the housing levy issue. They are being stopped at High Court. But thereafter, the status quo remains. So that is the question I have.
Thank you. I believe Wakili has had it. I see Marabu, Stock, and James have also requested. Let me add them. So Wakili, I hope you'll be writing down the questions. I see you requested for the mic. So, Muero, I see you're here. You want to say something before everyone else talks?
Yeah, sure. At the moment, I was listening in. So I was going over the Public Partnership Act of 2021, which I guess is part of the legal framework that this deal was. They basically utilized that act when they were formulating this deal. And it's just reckoning. And there's so many things I've highlighted here that I'm sort of waiting on people to join this space before I start raising my concerns. And it sort of explains why this deal has been crafted the way it's been crafted. But I was previously in a space overnight, and there's a lawyer that spoke and said that it's going to be really legally challenging to fight this bill in the courts, but I completely disagree. And the only explanation I can find, besides obviously the personal interests, and of course my personal speculation that Ruto is part of ADANI, and this is just a disguise for him perpetrating this deal. But there's also the fees that these entities have to pay that are proposing these kinds of PPPs. and it's reckoning how much money is required as a review fee. So there's obviously fees and money they have taken. There's obviously bribes that are involved. There's obviously personal interest in regards of their own private companies benefiting from this. But I'm just going to wait as people come in, and then I'll go from there.
Sure, Moira. Wakili, you want to say something before I bring in James and Marabu stock?
Well, perhaps we could just to say hi to our listeners and to thank the host and TG for granting us this opportunity to deliberate over these very weighty matters. I'll be weighing in perhaps at the appropriate times that we can dissect the situation as it unfolds. Thank you.
And thank you, Wakili. It's always a pleasure to have you on this space. James, we go to you, then Marabu stock.
Yeah, we had also talked about Tony reaching out to the media from that side as media to media. And I think also Mweru had said the Kenyan who works for an Indian media company is a friend, something of the sort. So it will also be nice to know how far we've reached with that.
Thank you, James. And Mweru will be right here to reply to you. Marabu stock, I see you're next.
Greetings in the name of the Most High. Hope you're fine. Anthony, TG, thank you for this space. Wakili, I have so many questions, but I'm going to limit them. Number one, at what stage currently are we with the ADANI issue? I'm seeing the government is saying it's still a proposal. I've also seen your litigation with Mount Kenya, and you're also not very sure whether it's still a proposal or it is a done deal. Secondly, we have a company that is registered in Abu Dhabi, and we are saying that some percentage of it is owned by Kenyans. What legal methods can we use to know these Kenyans who own this company together with the ADANI group so that we can greet them a bit? And another question is, when it comes to public participation, at what point is public participation required under the PPP Act of 2021? Because I've tried going through the act and I'm not seeing anywhere where public participation has been mentioned. And lastly, what is the timeline for litigation when it comes to issues of PPP? Because this is a matter of urgency, and I'm seeing the government is trying to pull your leg. So what is the timeline for this litigation, and how soon can Kenyans expect a resolution to this issue? Thank you very much for the time.
Thank you, Marabu. So you've asked some wonderful questions, and I believe Wakili wants to respond to a few.
And again, I want to thank all the members who are concerned about the events that are unfolding in this country. It is we who have been called by perhaps God or gods or whichever oracle to be where we are at this time and rise up and defend what binds us together. And that which binds us together is the aspect of our sovereignty, is the aspect of us being residents of a state called the Republic of Kenya. And a state cannot be a state if it is not guided by the principles of the rule of law. We can only regard that state as a pariah state. Unfortunately, this country is slowly sliding into that pariah state due to the collapse and overwhelming collapse of the governing system and structures in this country. It's on that basis, therefore, after our previous space, that I and TG sponsored a public petition that is still doing rounds in our social spaces. And the petition itself is calling for a self-introspection of this country and the affairs of this country. Among them is calling Kenyans to rise up and call for actions, and especially in matters regarding the ADANI issue. Further to that, today we filed a constitutional petition in the Constitutional Court that is raising very weighty issues. If you've read the petition, it has captured two issues. One, we are making an assumption that the agreement and the consensus executions have been finalized. The other link is we are making an assumption that they may be in a process of being finalized or executed. In all those aspects, we look at the Constitution, it contemplates a scenario whereby one can move to court to uphold and protect the Constitution from violation on an anticipated event or an event that has already occurred. That is under Article 258 of the Constitution, as read together with Article 259 of the Constitution. And why are we doing this? We are doing this because we have a rogue government, a government that does not believe in the doctrines of transparency and accountability. If we were in a democratic state, that as perhaps people might want us to believe, this information would have been laid bare for all and sundry to access. But you can see the process is being held in a very clandestine manner, shrewd concealment of material facts, so as to frustrate any person who might want to go to file and carry that process. And that's why you saw the LSK and the human rights taking the procedure that they took. They took the procedure of judicial review, which is completely different from the procedure that we have initiated. The procedure of judicial review seeks or looks at interrogating the process of the decision making. Was it reasonable? Was it rational? Was it lawful? And that's why you can see the court granted them stay orders. And if you can look at those orders, it speaks that leave shall operate as a stay. Meaning that due to the lack of the material facts, one may not be, they were not in a position to move through the constitutional mechanism to seek for declarations. Fortunately, we were able, TG was, and Mweru were quite instrumental in giving us the relevant information. As we speak, members must understand that this is not an anticipated issue. There is already existing feasibility study that was initiated and carried out by the ADANI group. That feasibility study was shared to me by Mweru. Secondly, it tells you if there is a feasibility study, then how was it initiated if the deal has not materialized? It tells you that the deal was consummated and it is at the process of the implementation. Subsequently, there has been an issue that was brought out by Senator Onyonka. So the question of the privatization of our airports and the other facilities like the KQ or the KAE, they have been subject of debate before the National Assembly. If you look at the report dated the 17th of June, 2019, when His Excellency President Uhuru Kenyatta attempted to privatize the same way William Ruto Arap Tama is doing, you realize that the National Assembly deliberated over that issue and came to a conclusion that there are some strategic national infrastructures that attracts question of national security that you cannot either lease, privatize, or alienate them for whatsoever purpose away from the reach of Kenyans. That tells you the reason why Mr. William Ruto Arap Tama is failing to initiate the process of approval by Parliament, because Parliament has already made that conclusion. And that brings me to the question that was put, the PPA and the question of public participation. We must all remember that the Public-Private Partnership Act is an amendment. And it was done and initiated by Mr. William Ruto Arap Tama for purposes of making sure that it alienates strategic infrastructures away from the poor of Kenya without their participation. If you look at Section 3 and Section 4 of that particular act, it has completely muted the voice of Kenyans. That Kenyans have no voice when it comes to the manner in which he chooses to implement the private-public partnership. And that is one of the gravagements that is pending before court. And that is why you realize that in all these hullabaloos and all these shenanigans, Kenyans have not been consulted. We have not been brought to the knowledge of what is happening. But you also realize that under Section 4 of the same act, there is a proviso that public procurement and disposal act will also be applicable where the state itself has initiated some investment. ADANI are not coming to build a new airport so that then they can completely be precluded or excluded from the ambits of the Public Procurement and Disposal Act. They are coming to proceed or to carry on with a going concern perspective. And the Act says they cannot privatize anything under the Public Procurement, Private Partnership Act if the government itself has invested in that particular project. And that is why information is being concealed from us. And that is why we're asking the High Court to interpret for us whether that can actually be initiated when we Kenyans have invested in the construction of the airport. But the PPA contemplates a scenario whereby if the project itself is a new project, then there can be an initiation of the public-private partnership and exclusively for the benefit of the members of the public through various models. That is not what is with us today. And the model that is contemplated by the PPPA is either a BOOT, that is build, own, operate, and transfer, or a BOO, build, own, and operate. As we speak, we are not aware of the model that Mr. William Ruto Arap Tama has initiated. It tells you that it's completely be alienated from our reach. Further to that, our petition has raised another issue. When you list this petition, this airport for 30 years, and when you look at Article 10, which speaks about the doctrines of sustainable development, and when you look at the preamble to our constitution, which speaks about giving ourselves this constitution and the future generation, then you incorporate the two fundamental principles of intergenerational and intragenerational equity. Does the bill contemplate the inter and intragenerational equity principles when alienating this property? And if it does, how does it then square out for the period of 30 years? Those are some of the issues we are raising in our petition. The other subsequent issue we are also raising is, can a strategic investment such as JKIA be alienated from the people without their participation? And if that so happens, what happens to the aspect and the idea of our sovereignty? Because our argument is that the JKIA and other airports domiciled within the Republic are symbols of our sovereignty. So when you alienate them without involving the people, you're simply saying that you're compromising our sovereignty and our heritage. Those are some of the issues we are raising in that particular petition. But again, to go back to the question of the public participation and why the PPPA has deliberately refused to invite members of the public to give or to weigh in their view, through their views, is to make sure that we are kept out of reach of what Mr. William Ruto Arab Tama is doing. And I'm using the word Arab Tama deliberately. Tama meaning a greedy person. Because he wants to completely own everything in this country. So we are waiting and we are anticipating that the court will render itself tomorrow for purpose of directions. But again, the deal as it is, and if you look at the feasibility study that was shared to us by Mweru, it tells you that these guys have advanced. For example, today during the strike by the workers at the airport, I have heard from the news that they have given documents in respect to that particular process or deal. Then it tells you that Arab Tama has advanced this deal to the exclusion of all Kenyans. Tony, I'll pen off and perhaps wait for further questions or clarification. Thank you.
Thank you, Wakili. And when listening to you and listening to how this government has been working from when it was sworn into office, one can't help but notice the pattern of secrecy and deceit in being their primary source of governing people. Keep it away from them until it's too late for them or until someone finds out. But as we contemplate that, I can see the name, accountability. The mic is yours.
Hello, Anthony. Yeah, thank you for this opportunity. So for me, I've not followed that much the ADANI saga because I've been busy with other things. Also, I'm not a professional lawyer like others. So for me, my point as just a normal Kenyan, what you will say about this deal is, these people should when they come to Kenya and start buying things, they should go through the due process. If they go through the back channels, a time will come when everything will be seized from them and they will be put in jail. So I don't understand why that is not in their head. For me, as a normal Kenyan, that's where I see this going. As you go through the court process and the court comes up with a judgment and decisions, I think at some point you will have to jail these guys and everyone who helped them and everyone who tried to give them the directions on what to do and who to bribe or who to give money to. So they should tread carefully. This is not their country, and I don't understand if they are adults. They are not adults. That's for me. Thank you.
Thank you, accountability. Now, as you were making your submission, I took time to look at examples of good, PPE deals. And I'll give you an example. When Elon Musk wanted to build a factory in China to do his electric cars, the deal was structured with quantifiable numbers. So he was told, we'll allow you to be tax exempt, but he was told on condition that you employ 100,000 people from this region, and that number should keep on growing as the factory and the demand grows. So when you look at the ADANI deal, there's nowhere you are told, they only say we shall employ people. ADANI being a person who has built airports, and that's being one of his specialities, he should be able to tell people that the ADANI deal, when I come in here, I'm going to create, he should give a number that these are jobs I'm going to create, this is the tax I'm going to pay, this is the amount of impact we shall have in terms of other sectors of this economy, like the steel, cement, people who sell stone. They should have such quantifiable numbers that I'll be buying this number of metric tons of stone, concrete, and all that. That way people get to look at numbers rather than look at a story. Another thing you notice with this government is everything they do is shrouded in mystery. So, Mweru, you can share a little bit on the document that you shared with Ndegwa. As I'm trying to find Wakili Kibe if you could request the mic from your end, then that pulls you up automatically. But Mwero, you can be giving us the insight into the document that you have so that Kenyans are able to hear about it.
Yeah, sure. I also sent you the Private Practice Act of 2021 in case there are people here who also are interested in reviewing it, because I also feel like people need to review that and have an understanding as to why this deal why Ruto seems to, or his government seems to have been extremely confident in carrying out this deal the way they have. But in regards to the ADANI deal, I'll also share that with you so we can share that in the space for people that want to also review that. But it's very saddening, the fact that for those that have not read the deal, they're projecting their main reason for initiating this is the fact that ADANI is, according to the deal, claiming they're going to offer expertise, innovation, a commitment to excellence, and deliver value and quality, and above all, sustainability. In this same deal, they have on page 79 to through 81 of the deal, the version I have received, they also list some of the dealings they have, and they do a lot of port operations, mining, they do a lot of power generation, renewable energy, gas infrastructure, supply chain, real estate. They're also involved in cement, media, a lot of stuff. And if you've paid keen attention, besides this whole airport saga that is currently going on, you can tell that there's also been documents released, which I cannot confirm whether they're actually viable, that also suggest that they've also started getting into the power industry in Kenya. So my point has always been, when you see such a scandal arise, you have to ask yourself, is this it, or is there more involvement? Because when I read this document, there was a lot of reference to 2019. And my assumption was this deal was initially, they started working on this a long time ago. This is not something that just started happening or they've started working on. So it was very relevant to pay attention to that 2019, because it feels like they started working on this then, which makes sense that there was also a similar deal that was being introduced in regards to Kenya Airways that of course failed. Which also now, if we start connecting the dots, you sort of now see why all this is happening the way it's happening. There's a pattern here. So the initial introduction in regards to KQ failed. Then in 2021, they proposed a new Public Partnership Act, and it's very appalling how malicious these people can be. But let me just go back to the deal itself. So the deal is proposing that, which is common sense. Everybody in the world knows that this is where we are all heading. There's going to be a passenger traffic growth. And according to the deal, they're stating that it's going to be an increase by 4.9% by 2050, which is going to be an increase, which they give it a number of 32 million by then. At the moment, our airport is servicing about 8.5 million a year. But by 2050, if this deal goes through, the proposition is we'll be having about 32 million by 2054. So they want to invest, the investment amount is about 2.05 billion US dollars, which honestly, if we compare to how much as a country we're generating in revenue, that is honestly, and this is in 30 years. This is how much money they're looking into invest in 30 years. But if you look at how much we're generating as a country in revenue, this is not a lot of money. We can essentially afford to renovate and run our own airport. As a matter of fact, we can't even afford to build another one. This is an economy that is generating up to 2.4 trillion, and this is the fiscal year of 2023 to 2024. So when we talk about we cannot afford to fix our own airport, that doesn't make any sense. And I don't want to resort to using profanity, because some of these things just take you to that. However, I mean, as we all know, our politicians only operate from a basis of personal interest, corruption, blah, 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 blah. So, case and example, if you look at Ruto's companies and the portfolio of his companies, it aligns pretty well and very parallel to ADANI's. He is involved in hospitality, in real estate, agriculture, insurance, all those things. So let's keep in mind that he owns a company called Martini Limited. I don't know whether that is still up and running. That is involved in real estate. He is involved in a lot of other things, and mostly just pay attention to his stocks. Like he's a shareholder in Kenya Airways, where he has about 80,000 shares. Safaricom, he has about 400,000 shares. So my point is that he has to have some form of benefit in the long run. And personally, I mean, the only way I can rationalize this is I think at this point in time, he's realized, his next candidacy as president is actually in real jeopardy and he might lose. And he wants to create systems that generate the same amount of money he's been stealing in the event that he ends up being out of office. And this is one of the ways. As I had mentioned earlier, I was waiting on people to continue joining the space and we have more speakers. So I can get into details about some things that I was reviewing, and I realized today that are pretty eye-opening, and I think I appreciate the effort that Degwa and Tony are doing where they filed this lawsuit. But there's also more legal things that we realize that based on this Public Partnership Act of 2021, it's basically grounds to vetoing this deal. I mean, it just doesn't make any sense how some of these people can. I mean, the only way to explain what is happening is the fact that they've taken so much money for them to agree to sign a deal that creates so much exemptions in taxes for this company. They have even, visas. I mean, they're just going to open the gateway for Indians to move into Kenya and just take up jobs that we don't have enough of. So, I mean, Tony, I'll just hand it back to you while we wait for more people and maybe give the other speakers a chance to speak.
Thank you, Moiro. So does this mean we are looking at state capture? Those are some of the things this very government campaigned against, that we will not see people line their pockets with money based on information they have in terms of dealings. And pretty much it seems like what is happening. The more you look at this government, the more you realize that they are the exact replica of what they were campaigning against. They promised people that we will not see any more auctioning happening. But as we look today, the economy is on a free fall. And I really don't know. Moiro, the more we have close to 400 people listening in. And I would really urge people to request for the microphone so that we have a more interactive space, because right now I only have one request and I'm trying to see if any other person has requested and maybe I'm not seeing them.
I have a question, because like I said, we are in the diaspora. So when I read this Public Participation Act, I have a question for our lawyer, Degwa. So under Section 5, it indicates that if there's any conflict that it comes up, this Public Act, this Provisions Act, is basically going to outlaw any other law that exists. Like whatever is stipulated in this Public Partnership Act is what stands. Nothing stipulated by other laws or provisions shall prevail. How should we interpret this? So do we just go based on this and forgo the Constitution? Do you mind sort of just tell me your thoughts on this?
Thank you once more, Tony. And I'm happy that we have more than 400 people listening to this space. Again, it tells you that we are determined to be our people and that we are going to claim our rightful place in this God's kingdom. And that we are not going to live as if we are being forced to live. just because one person has decided to lead this country through his own whims, wishes, and aspirations. We'll keep on reminding Mr. William Ruto Arap that this country must and will only be governed by the rule of law. We will not allow the rule of men to govern us. And so you can see Section 5 was designed for a particular purpose. So that and of course you must remember that this act, the amendment of this act came before the enactment of the Provision Act. So they were focusing somewhere. So they are using Parliament to legislate so that they can then steal from us. So the other weakest link that is existing in this country, that is perpetuating this mischief, that is creating the opportunities of Mr. William Ruto and his cadres to steal from us, is being facilitated by Parliament through legislation. How would somebody legislate Section 5 in a free and democratic state and tell us that the provisions of that act will prevail? It will prevail as against which other act? If you look at Article 227 of the Constitution, that article does not contemplate an enactment of an act of Parliament like the Public-Private Partnership Act that will compromise the principles of accountability, transparency, the rule of law, and all those aspects, and social justice. So Section 5 is designed to make sure that by the time we are done with Mr. William Ruto Arap, he'll have confiscated all that which he thinks. And that is why you can see the media is reporting that the ADANI deal has ousted the jurisdiction of the court. They are saying that this deal must flow smoothly, must be immunized from public protest, must be immunized from being challenged in court, and that if we challenge it, there will be damages accruing therefrom. But how can damages accrue from an illegality? If the contract was illegal ab initio, how will damages accrue? How can an agreement outlaw or out the jurisdiction of the court? It tells you that the enactment of Section 5 was designed to make sure that these guys steal from us. Fortunately, that is one of the sections that we are challenging. The constitutionality of that section. Can it apply in the current existing constitutional dispensation? Those are some of the issues we have put and challenged the High Court to tell us. When you say that Section 5 the act will prevail against other acts, you can only say that the PPP Act will prevail as against the Public Procurement and Disposal Act. And if you look at the level of transparency being created by the Public Procurement and Disposal Act is so high as opposed to the Public-Private Partnership Act. Remember, ADANI says that this was privately initiated proposal. That tells you a privately initiated proposal is somebody who is soliciting. Mr. William Ruto went to India, met with this ADANI and told them, I am intending to do this, initiate it. What that means is that they exempted us from the advantage of the expression of interest. Because the expression of interest would have been carried in the past for all and sundry to know. So any person who is interested in that project can then bid. But you can see Mr. William Ruto Arap decided to go to India and solicit for this particular engagement. Where does that leave transparency? Where does that leave the doctrine of accountability? Where does that leave the doctrine of the people's participation? Because at least would have been able to know that the government is initiating this process and perhaps would have intervened at that particular time of the expression of interest stage. But we shall tell him and remind him again that Kenya will survive many of us. Thank you, Tony. I'll still wait again. Thank you.
Thank you, Wakili. Mweru, I've just made Mweru my co-host so that if there's any request I can see, she can see it on her end. But I see we are also joined with new speakers. I see Wakili Ekuru Okot is on this place, and Kibe has had his hand raised for quite a while. So Wakili, Wakili, the mic is yours.
Okay, thank you very much, Anthony, for hosting this show. I have followed the discussion, and thank you, Ndegwa, for the explanations you've given, and I've enjoyed the comments by the other speakers. I think I'll just make a couple of issues because I think many of the points have been made and others will be made. The first thing, and I am aware that this matter is pending in court, is that there are a couple of issues to be said. Number one, I have read the government statement that has been issued by the spokesman, Mr. Mwaura, in which they are trying to say that this is just a proposal, but I think we have seen this before. When Kenya rise to oppose something, we know that many steps towards execution of this conspiracy against the Kenyan people and the country are already being taken to ensure the handing over of our airport in November this year. And therefore, this denial amounts to nothing, and the Kenyan people must maintain the pressure. Otherwise, this could just be a tactical retreat. Having said that, the points I needed to make are these. Number one is that even in a country where you have decided to adopt privatization in order to manage your debts, it has become public policy, is that there is always the extent to which privatization can be carried out. You cannot privatize everything. And that is why even at home, if you want to manage problems and something has to be sold, probably the family home would be the last one to be sold. It can't be the first option. And therefore, in a normal country in which a normal leadership would be in power, you would expect that JKIA would be the last public amenity that would be privatized, if at all we must privatize things in the manner in which we are proposing to do. The second issue is this. Jomo Kenyatta International Airport is a national security institution. And I believe this is why earlier in the year, a few months ago, 1 or 2 months ago, when people tried to demonstrate, you even deployed GSU. A couple of people are killed on the way on the basis that it is a protected area. Therefore, which insanity is this? That suddenly a protected area is being given to a Mzungu fraudster from an Indian fraudster from India on the silver platter and on sweetheart deals, and which they are even saying that if you stop any of the initiatives they are undertaking, that they would have to be compensated. Therefore, there is an element of contempt in the manner in which this matter is being taken by the government of Kenya. And ultimately, in my view, we would have to compensate it. Therefore, there's an element of... so what I'm saying is this, that something from the president's point of view, besides the obvious illegality that is there in this matter, the critical bit that one should even be more concerned is that its patriotism is being called into question. For what reason? For this reason. If you love this country, Mr. President, there is no way you can conspire with an Indian fraudster to give him JKIA for 30 years. And even this Indian fraudster, it is also incumbent upon him to be a little bit smarter. For the simple reason is this, that you cannot invest in a country where everybody is saying we cannot take this kind of investment. And therefore, if ADANI were to insist, and this should be made clear from the word go, if ADANI insists on going ahead with this deal, and the GSU is deployed to protect him, to keep JKIA, this deal will definitely come to an end the day after Ruto leaves to power. This is going to happen sooner or later, 5 years, 10 years, but one day it will happen. 30 years, ADANI will never have JKIA. The next issue, in my view, is the question of taxation. The question of taxation, in my view, is important. Kenya Airports Authority is one of the few institutions in Kenya that actually pay tax. If you start selling the family jewel, capital, assets that raise capital and revenue for the government of Kenya, it will then mean that the tax burden on Kenyans is even going to increase, because the scenario is going to be this: only the people of Kenya would be raising whatever revenue is required by the government of Kenya. Yet, in a serious country, Safaricom, KAA, Kenya Pipeline, and other profit-making organizations, including Kenya Power, should be sharing the burden of taxation. And this is therefore unacceptable for that additional reasons. There is also the question that what is required to be done is that we can afford that money. The economics of it, that we shall not be able to build more airports for 30 years when all our neighbors are building airport, is completely unacceptable. And it is why you would wonder, now that in State House everybody is supposed to be taking tea. Even when people are taking beer at State House, we never had this kind of insanity. And therefore Kenyans must rise against this. Finally, state power. In South Africa, we had Gupta. Kenyans must ensure that ADANI is not going to be the Gupta during this time of Kenya Kwanza. And finally, to ODM, Raila Odinga, who has been a patriotic citizen of Kenya and leader, must openly tell William Ruto that JKIA is not available for ADANI or any other gangster businessman who is a criminal. Thank you very much. I've enjoyed the discussion.
Kibe, Wakili Kibe, just before you drop, could we be looking at another Golden Bag scandal in the making?
This is worse than Golden Bag. Golden Bag was just about some minerals, fake gold that was supposed to be exported. It was a small timer. The ADANI thing, first of all, I need to emphasize that I believe, when I've read some of the clauses of the ADANI deal, that the true issue, apart from the management of ADANI that is going to be managed for 30 years, I believe deep down there are people who knows ADANI will not be there for 30 years. But the trick is this: within 2 years or 1 year of ADANI coming on board, ADANI can sell 2,000 acres from whoever it wishes of JKIA land. Therefore, is another land grabbing. The land around JKIA is high value land. And I believe part of the deal of ADANI is to transfer that land. So the deal could be, you make some money in the airport and you sell the land to the cowboys. This is why we must object to this. And this should be completely unacceptable. It is state capture of the worst character that one can never have.
Thank you, Wakili.
I hope I've answered
you have answered my question, and I just stay on. Mwero, before you come in, Mwero, I see Ekuru Okot is on the space, and I asked him a question, and he told me, Tony, we can stop this deal. Ekuru Okot, as you come in and tell us how to stop this deal, kindly take the mic.
Thanks, Tony, and thanks everyone for the space. Like I said, I hinted to you yesterday. You see, if a contract is bad and fraudulent, yes, you can take it to court and can be nullified. So I'm not so even worried about the fact. So we need to look at how good is this contract? Clearly, it is fraudulent, even in terms of just how it was processed in the first place. How did we arrive here? You know, like I think I had Ziti Ndegwa who said that there ought to have been an expression of interest, like we do in other projects. So that process, it wasn't followed in my view, even under our Public Procurement Act, which we all know. You know, there is a process laid down on how you secure certain projects. So if a contract is bad in law, like for example, that clause where that we cannot get out of it, there has to be an option for termination of a contract. If it isn't there, then it's not a valid contract. I'm sure Kibe and Ndegwa can confirm this. But having said that, can I make some 4 quick points?
Sure, Wakili.
Now, you see, I see this issue from a governance point of view. That how are we being governed as a people called Kenyans? You see, the first point for me is that this is a question about the rule of law, constitutionalism, constitutionality, if you like. William Samuel Ruto never believed in the current constitution, and consequently, therefore, he does not believe in the rule of law. That is why you can see there is total disregard, disdain for court orders by the executive. If you look at, for example, the current issue about Masengeli, the Inspector General of Police, you see the paradox is this, Tony. It is the police who, once they are given an order by the court to go and enforce, they will enforce it against a normal, ordinary Kenyan. But they themselves do not respect the rule of law. Masengeli was summoned 8 times. He sends his representatives. Now, the question sometimes I pose some of this most idiotic people in the space who say that we are being unfair to him. Would Lagat, for example, go and sentence on behalf of Masengeli? Once he's been convicted of contempt of court, he ought to come to court for conviction, or to come and show cause why he should not be sent to jail. Now, that you can see all that in terms of disregard for court orders, disregard for the rule of law. I mean, the other example I can give is, for example, the deployment by William Ruto of our National Police Service to Haiti against the clear provisions of the Constitution and Article 240, and even the National Police Service Act. It's absolutely clear that there is a process. Should you require the deployment of Kenya Police Service, there has to be a request from a reciprocating country. To date, we have not seen that reciprocating country. There is a court order that bars the deployment of police officers to Haiti, but he decided to go it all the way. So we need to look at all these issues from the ambit of governance, rule of law, and whether actually William Ruto and his Kenya Kwanza government believes in the Constitution. They don't. You will remember that he's one of the people who mounted a no campaign against this current constitution. So why are we surprised? So I am surprised, Kenyans are surprised that he's disregarding the rule of law and this constitution. Thirdly, I see it from the fact that the president disrespects the people of Kenya. He has no respect whatsoever for the people of Kenya. He thinks that Kenya is his chattel. Our parastatals are his chattel. Public spaces that are owned by Kenyans are his chattel. So it clearly shows that Chapter 6 under this administration appears to be a decoration. Why do I say this? Because if he occupies that office by dint of Chapter 6, you must show respect for the people. You must not demean that office. The president is not only is he demeaning his office by virtue of the fact that they went and negotiated this so-called takeover JKIA by a person who internationally is known as a fraudster. He has all the negative, you can describe in all the negative words. So what does that mean? In Kenya today, I can say that we are dealing with a very fraudulent leadership. And the last point I want to make is that it's now clear that government in Kenya is a business enterprise. It is not meant to serve the people of Kenya, but those people who are in government. So they want to capitalize, to monetize on the opportunities that's supposed to serve the people of Kenya. So that's my quick opening remarks, and to my 4 points, I want to yield the mic.
Thank you, Wakili. The more you look at how this KK government rules, you find that it is true when they say this is a shareholding government. Everything in Kenya, from the deployment of our armed forces to Haiti, is a transaction, not for the country, but for the few. But as we think about that, I see nothing is on the space. So we can have nothing giving us a contribution. Marabu stock then Joe in that order.
Hello, everyone. As usual, I start by saluting the comrades we lost in the protest, the injured and the missing. I also want to thank you, Anthony and Mweru, for giving me the opportunity, and all the speakers and listeners. On this JKIA issue, this thing is horrible from every angle you look at it, and I'm glad that the lawyers are here to help us expand on the issues. The number one mistake he made, he removed the visa option, which I looked up, and it was giving the country around 640 million a year. Was it necessary? Yet Kenyans, we have to pay for visas in majority of countries. I don't think, even where it's visa free, at the point of entry, there's a price you pay, there's a fee you pay. So why was it necessary if the issue is resources? Why did they remove that? Before that, KAA, it was during actually the former regime, KAA had a lot of money collected from the parking fee. I remember when it burned, and Honorable Sakaja was alluding they should use the funds collected, because apparently that kitty had not been touched for a very long time, and it was a lot of money. I will look up exactly how many billions it was and post. And they said, no, they're not allowed to use the money for the renovation after the fire. And then now I'm hearing them say, oh, you have seen that they were leaking roofs. There are contractors in Kenya and engineers who can do the repair work. When you look at the deal, it's a very disrespectful approach to handing over our national asset, because the security of a country is guarded through the border security. And for that reason, even the military should take interest and oppose this particular deal. But that notwithstanding, the state law office is supposed to help the government scrutinize our contracts and advise the government on what to follow through with and not what to reject, and clauses that should be included in a contract. But in this case, I'm wondering, was the state law office consulted? Did they facilitate this particular deal? Because the reason why we're calling it a deal and not a contract, the information came from a patriotic whistleblower. Imagine if Amenya, who we celebrate today, did not blow the whistle. What would have happened to JKIA? So I don't think they came to the table with clean hands. I don't think we should pay damages towards ADANI, because as a national security asset should not be handed to a foreigner, and worse still, to someone who has zero reputation in different countries, and not even far back in the years, currently is being opposed in Canada and in his home country. So why would you want to align yourself with such a company? So it looks like, and even when I saw today that they want an escalation of this clause of conflict of interest to be removed, I realized very quickly Kenya is going to become a private enterprise, because why would a sitting government remove a clause that is supposed to guard the assets of the country? He swore an oath to protect the sovereignty of a country. Why are we seeing part of the rule of law? There's the issue of agriculture, livestock, there's everything. Basically, it's like we are facing an imminent collapse. That said, it looks like he's not actually interested in running the country. And in the event that he's not, is it possible for him to resign? And in the event that he resigned, what is the way forward? And I don't think we should stop at it, because Kenyans have become like firefighters. We have an issue every other week. I remember they had mentioned that KICC can rake a lot of revenue if at all it is leased to a multinational company. Now it's time for us as Kenya to be proactive and look at what is the actual status of JKIA, because now they're saying, oh, it was a proposal. We need to know what is the title, what is the actual status at KICC, and also what is the KPLC. I looked at some videos where Julius Malema was explaining how when you go to bed with the West, they make you give away your national asset. The most profitable of them. And now we can see KA because JKA was not
Once again, my apologies for interrupting you, nothing, but we have so many speakers requesting, and a lot of people have pressing questions for their lawyers. So when you guys have your speakers, please keep it at 4 minutes so people can have a chance. Now that we have 3 lawyers on the panel, a lot of people have legal questions they want to ask in regards to this ADANI deal.
Thank you, Mary.
Okay, on that note, I wish to learn.
Okay, 1 minute. As you do that, I'll also take 2 minutes to go through the people who have sent their questions through through messaging. And someone has asked me to ask what is the implication of the meeting between the CS and the KAA workers. Does it have any implications in what will be going forward in terms of this deal? Ndegwa or any lawyer can answer that. Does it stop anything now that the KAA staff have said they're okay and they have done their strike?
Tony, I pass over to my seniors.
Okay. Kibe or Ekuru Okot?
I think the issue of JKIA is a matter that is bigger than employment. Employment is actually one of the smaller issues. Of course, it is a personal issue to those people who work for KAA. It is very easy for their concerns to be addressed and told that you are going to be retained on whatever terms and conditions that you are working for the time being. The bigger question still would remain that this kind of national asset cannot just be given for 30 pieces of silver, which is what is happening. KAA, anybody who wants to invest in Kenya is a very big country with only 1 or 3 or 4 functional airports. Other countries, smaller ones like Denmark, have even up to 10 airports. So we have a lot of land that ADANI and any other rich man from India or UAE can come and be given land to do an airport. But whilst there is no other airport, and whilst this is making some revenue for the Kenyan people, they are entitled to keep it, and a very clear discussion in which people are not pocketing money to sell the country's jewel is going to be undertaken. But for the time being, that discussion has not taken place, and therefore these things should actually be called off completely until the discussion has taken place as to what needs to be sold and what should go first. In my view, JKIA can only go last.
So we have a few people who have requested, but it looks like we're having a technical issue. If you're requesting for the mic, please drop and request again because we're not able to see them. So there's something I wanted to go over about this Public Participation Act. There's a few people who are here who are listening that maybe have not had a chance to review it. And according to this Public Participation Act, there's Section 37 that stipulates how PPPs can be acquired. And some of them that are listed there are procurement, private initiated proposal, competitive bidding, restrictive bidding. Those are some of them that are listed. So this ADANI deal, from my understanding, is a private initiated proposal, which, correct me if I'm wrong for the lawyers that are here, that it does not honestly explain why there was no competitive bidding or restrictive bidding that was part of this deal making.
Is that a question, Muero? Because someone
Yeah,
else asked,
because there's been a lot of I've seen a lot of conversation about why there was no bidding that was presented, but after reviewing this act under section 37, it stipulates, it sort of answers my question, but I sort of wanted clarification from the lawyers here.
And just to join that, because someone else has asked the same question, but he said, is it possible for Kenyans to know who else presented the PIP and who are the Kenyan shareholders in the ADANI in the ADANI LLC? Those two questions. So Ekuru or Kibe, any of you lawyers can take that question.
I think Ekuru can have that, or if he doesn't, I can take it.
Go ahead, Kibe.
There seems to be two questions. Number one, it is true that you can do a privately initiated proposal, PIP. But even when that is done, the procedure, and I think I'm aware of some of the facts which you cannot detail all of them right now, the procedure under which that would have to take place is that this fact must be announced to the people of Kenya even before it goes to cabinet, and we must have time to evaluate whether on what basis JKIA would even be available for purposes of such an arrangement. Because as you are saying, even at the family level, it is not everything that is available for sale, even if something must be sold. Issue number two, about whether or not we can know who are the partners of ADANI in this deal. All these kind of things are done for that reason. They are matters pending in court. The laws requires that every person who is going to benefit from whatever transaction that is of this nature must be disclosed. What are their identities? So this is going to be possible. But this is not, for me, the most important issue. The most important issue for the time being is that we learned about this deal when it had progressed considerably. Cabinet appeared to have met secretary and appeared to have said we have received this deal from ADANI and just communicate to the people of Kenya. The cabinet exercise public power, including the president, that this is property that belongs to the people of Kenya. So you cannot receive a proposal of that nature. You pretend to give reasons. You don't even tell the representatives of the people, which is parliament. Even if parliament some time back had said that they will leave the president and the minister and the CS Treasury to sell Kenyan property the way in which they want, they exercise delegated legislation. And therefore, in circumstances where you have a parliament that is a rubber stamp and has actually passed a law not to be involved in important decisions for the country, it becomes incumbent for the people of Kenya to be directly consulted on whether or not these kind of deals are going to be approved. And if they are not consulted, it is my considered view that that would fail under Article 10 of the Constitution, because we are talking here about public property and a matter of national prestige and a high-value public asset. It must be dealt with in a more responsible manner. It is not a matter of small technicalities of whether a certain law has been followed strictly or not. It is a fundamental question of whether in the first place is to be taking place, and if at all, with a fraudster businessman from India.
So yeah, if you can allow me just to add to what Kibe has said, please.
Yes, go ahead.
Yes, sure.
So, for example, under the Public Procurement Act, and even together with that PPP, you see, there has to be exceptions. Why are you basically almost like this is almost like direct procurement? What is the urgency in actually going ahead to say we need ADANI? And normally, even when you go for that kind of arrangement, you will have to consider a number of other interested parties. So you do what we call targeted. So it's like a head hunting. So you say, okay, ADANI or another person who is an expert in this, we want you to give us a proposal on this, but you have to demonstrate the urgency to it. In the absence of urgency, then the normal legal process follows. But over and above that, we are not just dealing with any need of an institution. This is about Kenya. This is a security installation. It's a public property. So you cannot privately procure a public property. You have to follow the process. In any case, honestly, like Kibe has said, Kenya is too big. If today, for example, you wanted to build another airport, we'll probably build an airport, say, in Isiolo, a very, world-class airport, and encourage tourists to fly directly to Isiolo to climb Mount Kenya, go to the Abadeas, and do a safari, But this, where is the need? Where is the urgency? In law, that they failed that test. Over to you, Mwero.
Interesting that you say that, Ekuru. And before we come back to you, Mwero, I don't know whether you have anything to add before we bring in Tony Gashoka and Marabu Stock in that order.
Yes, I do. Under Section 40 of this act, actually, Section 41, where we talk about the due diligence that has to be conducted in order for a PIP to be approved. A lot of this, ADANI is already, I don't think they conducted any due diligence, honestly, because it says pretty well, a private party cannot be debarred from any other country for participating in PPS. It cannot be corrupt, sued or convicted on any acts of corruption. It has to be tax compliant and is not on any default in terms of payments, cannot have any legal proceedings or bankruptcies, cannot be convicted of any crimes. I mean, we're all very fully aware, and it's public knowledge and information of all the crimes that this company has been plagued with. So, I mean, when we talk about violations of just this act itself that they seem to have engineered to help them with this kind of theft, it's already been violated. So for the lawyers here, please respond to this. So is this going to also help? And I know one of the lawyers, Ikuro, mentioned that he's almost certain that this is going to get voided. Is this one of the things that you guys are also bearing in mind when it comes to this lawsuit and petitions?
I confirm that in the case that was filed, I've seen those arguments by KHRC and the Law Society of Kenya. So thank you very much for your understanding of the law, and those are legitimate issues, and they are already part of the judicial review case that was filed on behalf of the Law Society of Kenya.
Thank you very much, Wakili Kibe. Tony, I wanted to bring you in so that we take a question from Marabu Stock and Joe. Then we can drop the speakers and bring in some more speakers because we have a very hot mic today.
Well, good evening, everybody. I wanted to talk about this concept of corruption, which is actually very well perfected by William Ruto, who trained very well under the Kanu regime. Corruption is, or what you call government corruption, is budgeted. So ordinarily, what you do is you get a need for a project, you give it a monetary figure, you put it in the budget through the treasury, the ministry advertises a tender, you shortlist a person that you have identified, then you award the tender, they go ahead and do the job, and then you pay. That is normally the way in which looting ordinarily happens in the normal course of business in government, budgeted corruption. As corruption has become more and more difficult to hide and has taken longer and longer because of the public's appetite for scrutiny and public participation, looters and crooks and fraudsters have had to improve their ability to heist and to steal. And most of the avenues left are now external. If you look at the SGR, for example, a lot of the looting of the SGR is external. A lot of the money stolen there is through insurance. People in Kenya do not actually know, because it is not something you ordinarily think about in corruption. How much insurance is paid per year on SGR? How much insurance is paid in terms of reinsuring the risk of SGR to Munich Re or Lloyd's of London or wherever else? These are sophisticated upper class ways of corruption. And what is scary about the Jomo Kenyatta heist under the ADANI group is the sophisticated nature of it, that it is seeking not just a strategic asset, but an asset that is earning dollars and euros that cannot be accounted for to the naked eye, that its revenues are invisible. People forget that over 200 tons of horticulture products are exported every day from Jomo Kenyatta International Airport, and those are legal horticultural products. What about those that are not legal, that go through aircrafts worldwide? I mean, if you go to the US-Mexico border, the narcotic trade is bigger than the economy of Africa together, because the narcotics that cross the border of the US and Mexico are in the billions of dollars. So if you have an unregulated Jomo Kenyatta International Airport, don't look at the land, and as Kibe Senior had said, my friend in the struggle for many years, yes, there is land and they can sell the land, but there are also sophisticated things that they have calculated that are beyond the naked eye. That is just cargo. When you look at why duty-free shops and all these things have been a problem in Kenya ever since the time of Kamla Patni and the World Duty Free sagas, it was because that is revenue that is recurrent and that is not accountable, because you cannot count it. You cannot be able to quantify it. You just put it in the pocket. As it becomes more and more difficult in Kenya to steal in national assets because of public scrutiny. Now, I want to say some issues that Mweru was raising as to why Lawyer Njeru and I have decided to go to the court for a constitutional interpretation. As Kibe will tell you, the LSK went for a judicial review mechanism that is going to question the propriety of the deal between the Kenya Airports Authority and ADANI, and whether or not it's a good deal, whether it was done properly, whether or not it stands the test of a public, award in the normal provisions of the law. But we, in our constitutional reference, are rising on the mountaintop of public concern, public interest in saying that the sovereignty of the people of Kenya, including public participation, is a prerequisite on all things, including gems like Jomo Kenyatta International Airport that are so important to the total citizenry of Kenya, that it cannot be even entered into any discussion without the participation of the public and the consent thereof. And our constitutional reference is asking the court to say that everything else is a nullity, in the same way they said the BBI was a nullity because the BBI did not originate from the common person. And it will be interesting to see whether the court will bite as to our demand that the sovereignty of the people is important in governance. Because if the sovereignty of the people through public participation, as was vested through the Bomas negotiations in the public, if that is upheld, it means that the public can continue. And that's why I had invited Morara today to come and tell us what he's doing going around the country, because if public scrutiny on public projects continues, it means that stealing public assets becomes difficult because the public are not involved. And if the public are involved, then that theft can be mitigated or stopped. And therefore, for me, the question here will be whether the courts will say that the public must be involved. And if the public say that they are not involved, and if they feel that the threshold has not been met, whether or not that contract can stand. And as Kibe has said, if it was to stand through authoritarianism, it will be anality later by succeeding governments. Now, where are we now in terms of the country and in terms of this ADANI issue? I think because of the online petition and because of the Kenyans coming up every day on this issue, it is becoming very murky for ADANI and William Ruto to close this deal, simply because the fine print of the deal would require what I am saying, the issue of exporting the theft of money from Kenya's borders to India. As you know, this is why this deal is being externalized. It's been externalized so that the amount of money that is divided is not divided here under the Controller and Auditor General, but divided by the accountants of ADANI. I don't want to speak anything beyond there, but to say that I'm putting a challenge to my brother Kibe to join with Ndegwa and Jiro, because we need not just a review of the ADANI deal. We need a constitutional pronouncement by the courts that this deal is null and void ab initio, because it does not, benefit the public, and in fact, it negates public interest. I want to stop there for now.
Thank you, Tony, for that very wonderful submission. And I'll just echo something you said as I bring in Joe and Marabou Stock to ask their questions and give us their submission. That what we try to do every Wednesday on Point Blank is we try to build a team that when Kenyans come to this space and give us their submissions, we try to be part of the solution of solving that problem that is really ailing this country. So, Joe, you're next. What is your question or what is your comment on this matter? If Joe is not ready, Marabou Stock, you can. If you're ready. Okay, Joe.
Evening, everyone. Mine is a question I would like to put to the senior counsels and including my good friend Negwanjiro. ADANI in Australia is, I think, a persona non grata at the moment. You go to India, there is a stock manipulations. Is there a way we can ban ADANI from doing business, any business? Even currently, the PIP has also on Ketraco. Is it possible we put an end to the name ADANI in Kenya through the courts? That is my humble submission to the senior counsel. That's what I would like to know.
Thank you, Joe. Senior counsel, would you like to answer, Joe, before we bring in Marabou Stock?
If I may give a shot on that.
Okay.
Yeah, so first of all, I think the most important thing is that we need the goodwill of the government of the day to be able to ban ADANI from Kenya. But fortunately for us, we are dealing with a corrupt regime that goes even against the laws they pass in Parliament. And after all, I mean, we know that Parliament is an appendage of the executive. However, to Marabou's question, yes, we can go on a constitutional petition and actually demonstrate as much as possible, but we need to gather enough evidence to demonstrate that this person is undesirable and he cannot possibly acquire this contract because of the way in which, I mean, if you look at the law as it is today, honestly, it doesn't qualify based on even his character internationally, and the fact that even if we were to invoke Article 10, that is sufficient enough because JKIA is actually a public good. And the courts already have established that in various decisions up to the Supreme Court. Public participation is not just public participation. It has to be meaningful public participation. So yes, on a constitutional petition, we can, I don't know whether we can get an order to ban ADANI from Kenya, but we can definitely stop the acquisition of JKIA using a constitutional petition, even by dint of Article 10 alone. But more importantly, I think, I don't know, I've not read the petition in court currently by Njiru and others, but we also now maybe need to invoke Article 35, the right to information. And the right to information is very clear. Information that's being held by a state or by any other organ. And I think this is something that we need to consider maybe as a matter of urgency to seek. the information about how, so that formally we know that this is what happened. Because currently, I mean, thanks to our brother who actually exposed this, blew this whistle on this deal, not a contract anymore. I think now we probably need to write formally to the Ministry of Transport and even to the Office of the President that by the end of Article 35, you owe Kenyans an explanation. How was this? What are the details about this deal? And I think if they refuse, then we can go to court, seek a court order, and probably to stop the whole thing and maybe join Njeru's petition. Yeah.
Thank you, Kuru. I think Senior Counsel Njero Ndegwa will tell you how best can you, Njero and Kibe, form a formidable team, you and Tony Gashoka, so that we're able to keep our country safe.
I wish to confirm, this is Kibe, I wish to confirm that Ndegwa Gino invited me to join, and I will join as one of the councils, and I believe Kuru Court has expressed a wish, so we can all form a formidable team. And I believe there are some other listeners here who have also raised a number of issues that they want raised in a petition of this nature. And therefore, there is going to be an amendment so that the issue of Article 35 raised by Kuru can be included. And also the issue of whether, in the first place, Kenya Airports Authority should have the kind of procurement powers that have in the first place invited these cowboys to try to make their proposal. Therefore, I confirm we shall do the best we can for the sake of our country, because now that we have serious failure of patriotism on the part of the president, every other Kenyan has a duty under Article 3 to be patriotic and fight for the important national assets of the Kenyan state. Thank you.
Thank you very much.
Tony, thank you. Tony, thank you. And you must use the word, the description of senior counsel very sparingly when we have Dr. Kuru Okot and Kibe within our precincts, so that I may not be penalized. Having said that, and I benefit with the wisdom of my seniors. One of the advantages that we have in that petition is that we have enjoined the union workers as part and parcel of the parties. Today, from what we have learned from the media, is that they have been granted some documents for which we are yet to scrutinize and see. And also noting that we also have the opportunity of amending the petition, so that any information that is left out there will be included. I keep on saying the more the merrier. We need to have these arguments benefiting the court, and especially from experienced advocates like Dr. Kuru Okot, Dr. Kuru, Senior Kibe, and the rest, and that we shall not tire until the right thing and what is just is done. Senior Kibe raised an issue about land being alienated. I have never had either a PPA agreement or a procurement under the Public Procurement Disposal Act, where the government is required to transfer land. Remember, the PPA contemplates two scenarios of engagement: the build, own, and transfer, or build, own, and operate. If you were to make an assumption that they are going to build, own, and transfer, why should there be a necessity to transfer land where the airport sits for only a period of 30 years? If then there was and to me that disqualifies the argument of the 30 years, because 30 years then there will be no necessity or requirement that land should be transferred. They just come, lay down the infrastructure if we are to agree that they must come. But on the question of transferring the land where the airport sits on is a clever way of trying to steal that land by this guy I'm describing as William Ruto Arap Tamar. So that the alienation of this land will take place when and then these crooks are in possession of that land. Suffice to note that the PPP, the Public-Private Partnership Act, has created kind of some loose stopgap measures and safeguards. They are saying that the procuring entity will scrutinize whether the other contracting party has been involved in corruption, his credibility and his integrity. If that then was to apply, who doesn't know the ratings of these Indian crooks? So to me, Mr. William Ruto Arap Tama has high affinity of those people who have questionable character. He has a very soft landing for them because he makes and uses them as an accessory to steal and enrich themselves. I pen off and still continue participating.
Thank you. Maro, you have something you want to say?
Yes. So in regards to the news anchor in India that I reached out to, my last communication was this morning, and the response was they're very surprised because initially when I reached out to them about reporting on this petitions that we were filing, according to them, the bosses just lended him a deaf ear and sort of dismissed the story. But after what happened today, where the issue with the airport, now they're regretting that they didn't take up the request when I sent it to them. But they're also working on currently, like right now, taking up the story and doing full report, because initially we realized that we need to exert more pressure too in India, and if we can have the press working with us in this manner would be of great help. So anyway, as we proceed, we have, besides the lawyers that we have present and Tony, we have a lot of speakers who have questions. So I'll have Marable, please take up 3 minutes in regard to this issue, ask your questions and make your comments. And then after that, we'll have Dr. M. And then from there on, we'll start approving new speakers, but please just stay in topic and just take up 3 minutes. Thank you. So Marable, please proceed for 3 minutes.
Thank you very much, Umaru, and allow me to appreciate you because you've really brought out some things which we wouldn't have known without you reading. Number one, my question goes to Ndegwa specifically. We deal in a precedent system whereby we judge things according to past judgments. Is there a precedent for PPI cancellation in Kenya right now or within the Commonwealth that you can refer to? Second question, I hope you have a pen because I want to ask like 4 questions and rest my case. The other question is this. I've seen you've mentioned the Attorney General as part of your respondents. Is it number 4 or 5? So what is the function of the Attorney General in a PPP procedure? And was the Attorney General of Kenya, in your knowledge, available when this PPP and ADANI deal was being made? Lastly is, if, for instance, we are saying we don't have money to develop JKIA, what would be other methods that we can use to generate income or to generate money enough for us as the citizenry to develop JKIA without having it alienated? Lastly, let me thank Ekuru Okot. I'm still waiting for your book, Punguza Mzigo. I've waited for that book for years, and I expect you to write that book very soon because you're one person with enough resources and enough resolves to change this country by just writing something about what you've seen. Lastly, if the law is defective, and I heard Njeru say that they changed the 2013 Act but with the 2021 PPP Act, so I'm assuming that it has defects. So are you thinking of reviewing the law? Should we review the law, or will we continue with the PPP Act 2021 as it is? Thank you very much for the time, Anthony and Mweru. Thank you very much.
Anthony, one advantage I have is that I have the seniors with me. And of course, even if the questions have been directly directed to me, I'll take question 2, then I pass over to Daktari and Kibe. On the question of the role of the Attorney General, remember the Constitution just speaks that he's a principal legal advisor to government, and Mr. William Ruto is a person who takes advices from the person he has advised to advise. So as to whether or not the Attorney General's office was involved. I think that is something I cannot be in a position to explain. But ordinarily, when you have matters involving government, the Attorney General, being the principal legal advisor and representative of government in civil suits, then it's always very much advisable for you to join him or her in the proceedings. I pass over the first question and the other questions to Dr. and Senior Kibe.
Daktari, a court or a senior?
Senior can go first.
I think I didn't get the questions because he had said that he's asking Ndegwajiro. As you tell me the question that I should respond to, I didn't get it very well.
Maybe we can pick.
He's asking. So, maybe refresh us on the question, please. That we're supposed to answer, me and Kibe.
Council Ndegwa, you can refresh, or I can request the person who has to DM me the questions.
I think that would be the latter would be appropriate.
Okay, let me do that. But meanwhile, as I do that, we can be getting some more questions.
Yes, so Dr. Milton, go ahead, please, for 3 minutes.
All right. Thank you very much. I want to join the rest of the comrades in this space and in several other platforms. First of all, in paying tribute to the men and women and fellow citizens that have paid the ultimate price in the quest to hold this government, which is clearly a rogue cartel of individuals. That the people who have paid the ultimate price, we have a commitment to salute them and make sure that we do everything to ensure that their spirits can rest, knowing that even though they did not live to see the fruits of what they were fighting for, there will be justice and they can rest in peace. Now, I would like to address myself to 3 pertinent issues that I think we need to focus on as a people in keeping this government under pressure and so strong that they will have no option but to vacate. So number one, when you look at how the ADANI group deal was entered to, one of the questions that we must ask ourselves, and perhaps without appearing to be watering down what Senior Ikoro and Kibe would speak about, the role of the Attorney General and the company secretary for the Kenya Airports Authority, the CS as the chief policy advisor to the presidency, and even to some extent the Solicitor General. I believe that time has come that even as we talk about these issues from a general perspective in terms of the public interest being shafted while these deals are being negotiated, we need to be able to now begin directing our anger at those individuals who hold office or held office at the time when these deals are being negotiated and being put together. Because the Attorney General, and in this case, I would want to speak to the former Speaker who's now CS, J.B. Muturi, who was Attorney General. He cannot escape responsibility as the Chief Legal Advisor to the government. The Solicitor General cannot escape because they have a duty to ensure that there is public interest and value for money is at the heart of every deal that is entered into. The CS, as the custodian of policy on behalf of the people of Kenya, has a duty, an obligation to tell the Kenyan people what happened. And then there is at the institutional level of Kenya Airports Authority, there has to be a level of responsibility when it comes to the Corporation Secretary, who's the chief legal advisor of KAA. What do these people, what has their role been all along? And I believe that time has come for the Kenyan people to invoke the power that is inherent upon them, to call these people to account. And in all these petitions, I would want to submit that they need to be parties, respondents in these cases in their individual capacity, because they took office and took an oath to perform the functions that are spelled out in the Constitution as to when situations like this arise. And therefore, they cannot escape. So as we move on and agitate, I think we have a duty to bring them to account in their individual capacity. That is how we are going to ensure that people don't just masquerade, don't just say, okay, I have advised and therefore it is up to the people to take advice or not. What do you know? That is negligence, and it is unacceptable in the circumstances. I want to move to the next point that I would like to make in this sense. While we are holding these people accountable, we also need to remember that we are dealing with a presidency, an occupant of office, where such a deal could not have happened without State House and the brokers and the people who purport to be close to the presidency must have been the initiators of this. And we need, therefore, to know what happened. How did all this start? Who are the proxy companies that are involved in this deal? We have seen the Ketraco letters that were being done. Who are these? Who are the shareholders? Who are the directors of this company? And how did all this come into being? That is how we also need to look at that. And Kenyans who have information, we want to plead with you that please, from wherever you are, as a civil servant, as a public servant, please share that information in confidence, and so that we can be able to reclaim our country. This is just one of the many deals. And I think this calls for an audit, a detailed audit of every single deal, every single decision that this government has made since William Ruto was sworn in. Because this, I mean, our country could have been sold. We may be talking of a country, and every single deal that or decision that has been taken is, smaller, different levels of the ADANI group deal. We need, and I think Council, Ekuru, Kibe, and Degu, and others, we probably need to contemplate an institutional framework where we research on every single foreign trip, every single decision that has been taken by this government, and audit what has come out of those decisions and what is in it for the Kenyan people. I am really, I shudder to imagine what else could be happening with all the construction deals, all the mega projects that we are being told about, all the bags of goodies that we have been lectured to by our brothers from the government. I'm landing. So I'm just calling upon all of us to take it upon ourselves and push, audit every single deal, every single decision, and so that we can be able to audit this government, because clearly they are up to no good and they could be auctioning our country, and the only thing they are keeping us busy chasing rabbits when the antelopes and the elephants are somewhere and our country is gone. And lastly, I would like to personally reach out to the council here And I would like to join in the petition, not just this one, but many others, so that we can be able to articulate the issues and be able to hold these people into account. Thank you very much, and let this continue. Let the pressure continue increasing. May God bless you all. God bless our country.
Thank you, Dr. Milton. And you've asked some very good questions. And one was actually one that was asked by Marabu Stock. Is there a possibility that we can either cancel the PIP done by ADANI or renegotiate it? That was his question. And the role of the Attorney General in all of this. So are we focusing on the wrong people? Do we need to now look at the role of the Attorney General and the Solicitor General in all this? And the last question Dr. Milton asked about the deals that the government of the day takes on behalf of Kenyans. Councils on this panel, could we be ending up with another SGR where we don't know what was signed, the cost and everything, and we are just told we need to pay? I think we start with Senior, then Ekuru, then Degwa, in that order.
Yes, let me start off with the issue of the Attorney General. From the facts that I'm aware regarding the JKIA, it would appear to me that the principal actors appears to be the minister who was responsible for these matters of transport and the JKIA individuals, either the entire board or some of them, together with people directly associated with the President of Kenya. To some extent, there are some facts indicate this matter was presented to cabinet, but meetings of cabinet are always done in a hurry. So, but to be able to know that you want the Attorney General involved, that would have required a process that is a procedural and accountable, so that in the process of it, the Attorney General would give an opinion whether it should proceed or not. But the trouble with the PIP issues is that there is almost an assumption that there is almost an assumption that it is a matter for Kenya Airports Authority alone. But when you cast the question broader and say it is an important public asset, then that is where you would draw the Attorney General in. And therefore, these arrangements of PIP, PPP, some of them can easily be used to rob a country dry, and they need to be re-examined. I believe there is an appeal of that nature. But of course, there is an institutional failure in the sense that under our constitution, the Attorney General, Article 156, on one hand, you say is the legal advisor of the chief legal advisor of the government. On the other hand, you say that is the protector of public interest. On a day-to-day basis, the Attorney General behaves more like President's lawyer, more than the guardian and the custodian of public interest, so that there is an internal conflict in which individual attorney generals have discharged their role. When you go to Israel, for example, and they do not even have security of tenure, the Attorney General is the one who has been able to ensure President's sycophants. They always take the position of the President, and the general public can go and hang dry. If there was a responsible Attorney General who is effective, I do not see how this deal would have reached the stage where it has reached, and at the very minimum, would have issued a statement saying, because this is a matter of grave legal and constitutional moment, that these issues have arisen. This is the position of me as a protector of public interest in Kenya. This has not happened. And it has not happened for the simple reason that either very weak people are attorney generals in this country, or they simply decide to go on the side of the president, so that if the president decides to be anti-people, the attorney general ends up being anti-people. That deserves to be addressed as a matter of urgency. I think Ekuru Aukot can take the other question.
But maybe Kibe, before I need to be reminded on the other question, but I think I need to say it categorically. Yeah. I need to say it categorically that I believe that the office of the Attorney General was never involved. If you will all recall the lamentation by JB Muturi, he said that his advice was ignored, especially when I think we are litigating the Haiti case. We sued him, yes. But at some point later on, when we got the orders of the court, I think he came out to the open to say that he was never involved. My honest opinion is that this is more of a political deal than anything legal. And I believe I want to bring in here the role of the Law Society of Kenya against its members. Kipchumba Murkomen, who was then the minister, the CS for transport, must have been involved in this deal. And I think for me, it's time, Kibe, and I think you'll agree with me and Dr. Milton as well, and Ndegwa, that if the conduct of an advocate is unbecoming, I think this is a matter that can also be escalated to the disciplinary committee of the Law Society of Kenya. It needs to be someone to come and explain how did this deal happen, and under your watch as an advocate of the an advocate of the High Court of Kenya. I believe that is another thing that another pressure point we can actually apply. Now, what is the other question by the attorney that I'm supposed to respond to? Tony.
Another question was, can the document can we have a situation where all dealings done on behalf of Kenyans, can those documents be made public? How can citizens have that, so that we don't have another SDR where we are just being told, China, we need to pay this amount of money?
Okay, ordinarily, and even as the law stands today, all such dealings about the country ought to be made public. And that's why when we were doing the constitution, we were clear in Article 35 that information held by the state, you can actually demand for such information. And that's why I was suggesting earlier that perhaps in Ndegwa we need to amend this petition to actually include Article 35 of the Constitution of Kenya. Because in the absence of that, in the absence of this information, because it is affecting the rights of Kenyans. So a state organ or any person holding information that affects my right as a person or as a group actually ought to make that information public. And especially in the context, say, of a public entity like JKIA or KAA, even just administratively, and Article 47 of the Constitution, they actually owe Kenyans an explanation. How did this happen? So yes, that information ought to be made public, and I think, except perhaps it's not very clear in the Constitution, such kind of deals. But I know, for example, and when you look at Chapter 5, when looking into natural resources, by the end of Article 71, if I'm not wrong, it ought even to be debated in Parliament. But the principle in law is there in the Constitution that anything of public interest that affect as public policy implications ought to be debated by the representatives of the people. This has not happened because this is a hush-hush deal struck between the president's men, the board of KAA, and this crook called ADANI, who, in my view, honestly, I don't really care whether he is given this contract eventually or not, or reconfirmed. I think we need to invoke Article 37 of the Constitution. We need to take to the streets and oppose this man from taking over our JKIA.
Thank you, Wakili. And Ndegwa, you want to add something before we take in some more questions?
Before he proceeds, as we go on with the questions, I would like to mention that when Ndegwa is finished, we'll have Joy. Joy, please keep your submission at least 3 minutes and your questions brief and to the point. And then Joy will be followed by Owiti, and then we'll have Titus before we introduce the new speakers. These three have been here for quite some time.
I can't hear Ndegwa speaking, so I'll make my submission and then probably he can come after me. I want to chime in this from the perspective of a quantity surveyor. I am a quantity surveyor myself, and on typical projects, we would be the contract administrator, so maybe lawyers for construction projects. Now, I have looked at the PIP document by ADANI, and I do have some questions, very pertinent questions any QS would ask. So, for example, when they justify a PIP of a competitive bidding process, they are saying that a PIP would which is the process that they are going through, will allow them to give us more benefits without looking at value for money as being the main benefit that we are looking at. But when you read at the beginning of the document, they say that actually they are coming in to help because the government has a fiscal deficit to the tune of about 5.6%. So if actually the reason why they're coming to help is because the government doesn't have money, then why shouldn't the main consideration be value for money? Why should we go through a PIP process and not a competitive bidding process? Because if we went through a competitive bidding process, we would actually get that value for money justification that we'd be looking for. And then again, I think it's actually not factually correct to say that going through a competitive bidding process, the only thing that you look at is value for money. When we score tenders, we score them based on both quality and pricing. And I don't think that them claiming that they're giving us any other benefits other than value for money is correct. Two, they're talking about the time that it takes to bid. They're saying if we were to go through a competitive bidding process, we would need to add about 18 months to the bidding process. But we as Kenyans, if we go through this, we'd need to give them our airports, literally hand it over to them for 30 years. What is 18 months over 30 years? Why are we giving away the family silver to people that have got no interest in our children's futures? What is 18 more months to make sure that we are securing the future of our children's children? Number two, the 30 years that ADANI would take over this airport for, whatever investment they would make, I can guarantee you, but that by the time they are done, the useful life of everything that they would have constructed would have come to an end. So would literally be back to square zero. Buildings have a useful life. Most of them, if it's very good quality, it will give you 50 years. But after 50 years, actually, it might make sense to knock it down and build a new. So in these 30 years, because I don't think they would actually have anything that entices them to give us infrastructure that is more than the 30 years, would still be back to, because would now be industry almost entirely dependent on them, would be back to, again, looking at how to extend that so that they can put in more investment. Because by that time, I would imagine that the public finances that are going to JKIA right now would have been channeled elsewhere. And so it would be a whole other process to try to get the government again to own this asset on our behalf. Now to the question. I am a bit concerned at the speed, and again, going back to the justification that ADANI is giving, that 18 months gives us better value because it cuts the procurement period for. I am very concerned at the importance that negotiating deals seems to be praised by the government of Kenya. And I say this because I live in the UK. And when the UK was leaving the EU during Brexit, it was looking to sign new trading partnerships with other governments, Kenya included. Do you know that the speed at which the trading partnership between Kenya, it's called the EPA, the Economic Partnership Agreement, between the UK and Kenya was signed, of all countries in the world, was the fastest. The fastest. And if you look at that document, sorry, I'm digressing. If you look at that document, there are specific clauses that say that actually, because we are giving concessions to the UK in terms of the tariffs that we are going to charge them, there's some sort of economic disbenefit that this might accrue to Kenya. Why would why would the government sign that? And then two, when this was signed, people from the Ministry of Trade, I can't remember what specific ministry they were, but they were very proud to have done this in the fastest time possible. So why lawyers would like to understand why is time, and is there any legal mechanism that can be put into place to make sure that time is not the only thing, getting things done fast, because it looks like we are losing a lot in getting these things done, because literally we are handing out our most valuable assets, our economy, our economic benefits, just because we want to be seen to be the fastest to do things. Is there something we can do within our laws to make sure that we are not giving away family silver just because we want to be the fastest? Thank you.
Thank you, Joy. Now, Moero, you told me you had the list. So, Joy, what was your question, and which wakili would want to take it? I kind of missed it also.
Yeah, sorry. My question, this is more of a general question, and it's not to do specifically with this. I'm just very concerned that, one, there seems to be an emphasis on speed. Signing these agreements, and some of them with very that give the country a lot of disadvantages rather than advantages. So the example that I gave is that when Kenya was signing the economic partnership agreement with the UK, they did it in record time. I think actually a matter of weeks after the UK left the EU. Other countries took years. For example, India negotiated with the UK that their young people can come to the UK with no visas to look for jobs, for a period of time. Kenya would have done that if they had taken more time to negotiate that with the country, but they lost us that benefit, for example. And in doing that, they also seemed to give away a lot more than what they would have been expected by just a rational person, right? Now, coming back specifically to this deal with ADANI, ADANI seems to be justifying the use of PIP over competitive bidding, which is what any rational procurement or QS for construction projects would do. You would get many bidders and then have them all do their offers, have them all, submit their tenders, and then you assess those tenders. But they are saying that we propose you don't go through that process because that process adds 18 months to the whole timeline of getting this thing agreed. But if we were to agree this, we would give them the asset for 30 years. So what is 1.5 years over 30 years?
So I get your question. Your question is, if I'm not wrong, why is it that Kenya seems to always be in a hurry to sign a deal?
Yes, exactly.
Yet if they took more time, they would get a much better deal.
Exactly. We would have more negotiated. And is there any mechanisms that can be put in law to make sure that we are not emphasizing speed over, any lawyer can take it here.
I think we are left with the Kuru. So let's have everyone ask their question, then Kuru can reply, and then we can close it at around 10, 20, 10, 15. So Moero, you have the list that you can give the order.
Yeah, so next is Owiti. Please keep your questions very brief and submissions.